Good evening, everyone, and welcome to our first ever virtual Bainbridge final competition. Obviously, COVID has changed a lot of things about how we run this annual competition, but the one thing that hasn't changed is that we have had remarkable competitors and also remarkable judges. We have two excellent competitors this evening who I understand were part of a team of 15 competitors that were whittled down to Margaret and Karen. We also have a first this year in that we have a FlexTime student who is one of our finalists. It's the first time we've had one, so welcome. We're very proud of that fact. Our judges, who I think Allie will introduce, are some of the most well-known and well-respected legal experts here in the community, and we are very fortunate that they have given of their time today in order to do this competition in this format. I want to thank everybody who's here. I think you will see some excellent arguments today on a Fourth Amendment search and seizure issue, which are always fun to argue. And everybody enjoy, and let's wish Margaret and Karen both the best of luck. Whichever of the two wins, they're both wonderful competitors and they both deserve to win, but I don't think the judges can do a tie. So Allie, why don't you go ahead and introduce our judges and continue with the program. Thank you all for being here.
Thank you, Dean Langan. Good evening, everyone, and welcome to the 38th annual John S. Bainbridge Moot Court Competition. My name is Allie Albano, and I am the editor-in-chief of the Toro Law Moot Court Honors Board. While this year has been anything but ordinary, we are proud to present this competition via an online modality for the very first time. With the aid of my extraordinary colleagues, advisors, the IT team, and the administrative team, this virtual event was made possible. We are honored to have our esteemed judges here with us tonight, the Honorable Derrick Robinson, President of the Suffolk County Bar Association, Mr. Dorian Glover, the President of the Nassau County Bar Association, and Mr. Howard Stein, partner at Certilman Balin, Adler, and Hyman. We're also honored to have our two finalists, Margaret Goodman and Petoske, here competing with us. Without further ado, I present to you the final round of the Bainbridge competition. Good luck to you both. Nicole, take it away.
Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are now admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good evening. Will the petitioners, the competitors, please state their names, please?
Margaret Goodman for the petitioners, United States Customs and Border Protection Agency, Travis Smith and Tracy Morgan.
And Karen Petoske for the respondent, Mr. James Garcia Lopez.
Thank you. Please proceed.
Good afternoon, Your Honors, and may it please the court. My name is Margaret Goodman, and I represent petitioners, United States Customs and Border Protection Agency, Travis Smith and Tracy Morgan in this action. At this time, I would like to reserve 1 minute for rebuttal.
It's granted. Thank you.
Would the court like a brief recitation of the facts?
I think we will pass on that, and we are familiar with the facts. You can proceed.
Your Honors, this case is one of Border Patrol and its agents who executed a lawful search of a traveler's electronic device in order to secure this nation's border and protect the country against the entrance of contraband. Petitioners respectfully request that this court reverse the lower court's decision for the following 3 reasons. First, the search of respondent's laptop was permitted as it fell under the border exception to the Fourth Amendment. Second, the government's interest in border security far outweighed the respondent's privacy interests. And third, reasonable suspicion is the highest standard required for a search at the border. And if this court were to deem that reasonable suspicion was necessary, it was met. As to petitioner's first point, the search of respondent's laptop was permitted as it fell within the border exception to the Fourth Amendment, given that the government has a heightened interest in national security at the border. The border exception—
Counselor, isn't the difference between what this court has decided before and information on a laptop a little different?
Yes, Your Honor. While petitioners can recognize that there is a difference between prior rulings and electronic devices, court has held in the case United States versus Ramsey in 1977 that warrants are never necessary in order to conduct a search at the border. The United States has a long-standing right to protect itself by stopping and examining persons and their property when they present themselves for entrance at the border. Further, it is the goal of Border Patrol to protect the country against the entrance or exit of contraband. As the Ramsey court held, a warrant is never needed when conducting these basic border searches in order to accomplish this goal. Thus, the border search—
Ms. Goodman, may I inquire, are you suggesting that a single male, a frequent traveler coming from Mexico, and based upon an agent's expertise justifies that being a reasonable search as a criteria?
Yes, Your Honor. This court held in the case Montoya de Hernandez that we must consider all of the relevant facts of a case when determining whether a search was reasonable. Here, when we consider all the relevant facts that you listed, the search was reasonable. Further, the respondent here consented to the search of his laptop by providing the password to his device. By providing this password and providing his consent, petitioners can clearly say that the search was reasonable given that he consented to whatever the search was. As to petitioner's second point, the government's interest in protecting the border far outweighed the respondent's privacy interests. This court held in the case United States versus Flores-Montano that Border Patrol agents could search a traveler's gas tank and found that it was not intrusive because a person's dignity and privacy interests cannot be transferred to their personal property. In applying—
Counselor, are you equating searching a gas tank with searching someone's personal computer as being an equivalent determination of privacy?
No, Your Honor. Petitioners recognize that this court held in Riley versus California in 2014 that electronic devices are quantitative and qualitatively different. However, this court has also held that a person's privacy interests cannot be transferred to their property. And while an electronic device might contain some information that is sensitive, it also likely contains a significant amount of information that this court could not find to be personal, private, or sensitive.
Can you truly say that a search of the data device is not a significant intrusion on an individual's?
Your Honor, the 11th Circuit held in the United States versus Toussaint that some level of intrusiveness is required in order to effectively control and secure this nation's border. Further, if we were to exempt electronic devices from border searches, Border Patrol will be hindered in accomplishing that very goal that they are tasked to complete. Your Honors, people can enter this country with mixed motives. For example, in the case United States versus Cano, a traveler entered this country with the express intention of finding work. However, while doing so, he was also smuggling drugs in his vehicle's spare tire. Here, while the respondent's express intention of entering the country was to pursue his legal education, that does not give rise to the fact that he may have been smuggling drugs as an alternative and possible mixed motive. In considering that, we cannot say that we should not have proceeded with this search, and no special treatment should be given specifically to electronic devices. The court has held in the case United States versus Flores-Montano that one should anticipate a lowered sense of privacy at the border than they would experience in the interior. Given that—
Ms. Goodman, can you speak to the detention period? We're talking over 24 hours. Is it your assertion that that was reasonable here?
Yes, Your Honor. This court has never given a bright line rule of how long a search should be before that search becomes unreasonable. In the case United States versus Montoya de Hernandez, this court upheld more than a basic search that lasted up to 16 hours when Border Patrol agents believed that the traveler was smuggling drugs in her alimentary canal. Given that they performed more than a basic search lasting over 16 hours and that this court has never given a bright line rule on time, yes, it is petitioner's contention that this was a reasonable length of time. Further, when he consented to the search, he also consented to whatever period of time the search would take. The time itself does not indicate that the search was more or less intrusive than was stated.
Thank you.
As to petitioner's final point, no warrant or reasonable suspicion was necessary in order to perform this basic search of Mr. Garcia Lopez's laptop. The Fourth Circuit held in United States versus Colses that reasonable suspicion is only necessary for a forensic search. A forensic search is one where an agent or officer would employ specific equipment or specialized software in order to look at or view the information stored on the device.
Ms. Goodman, are you suggesting that they didn't have unfettered access to what was on the computer and somehow it was limited?
Your Honor, given the fact that Mr. Garcia Lopez consented by giving his password, he provided to the Border Patrol officer whatever information was available by giving that password. And that was something that he consented to willingly and voluntarily. Reasonable suspicion was defined by this court in Montoya de Hernandez as a particularized and objective basis for suspecting a particular person. However, given that this was a basic search, it was not necessary here. Even if
Counselor, how do you define basic?
A basic search is one where the searcher would use it in the same manner that the user would use it. Given that Mr. Garcia Lopez provided his password, the Officer Smith could only search the laptop in the same manner that Mr. Garcia Lopez would use it and had access to the information that Mr. Garcia Lopez gave him access to. Even if this court were to find that reasonable suspicion was necessary, it was met here. Mr. Garcia Lopez shared common characteristics with known drug smugglers, which gave rise to Officer Smith that he should move forward with conducting this lawful search of his electronic device. Mr. Garcia Lopez was a young man traveling alone from a known narcotics country and only had with him a laptop, keys, and a newspaper. Further, this court has held in United States versus Montoya de Hernandez that we must trust the expertise and experience of these officers. Officer Smith 1 week prior stopped a similarly situated person, which resulted in him finding a large narcotics smuggling ring. Upon further investigation and making reasonable efforts to obtain all of the relevant facts, such as the frequency of his travels between the United States and Mexico, the purpose of his trip, what he intended to do, who he intended to see, when considering all of those reasonable facts and using his experience and expertise, Officer Smith still found that a search was necessary, as opposed to United States versus Montoya de Hernandez, where when considering all those relevant facts, where the traveler had no real details about her trip and showed physical signs to Border Patrol that she was smuggling contraband in her alimentary canal. By both of these cases showing that all the relevant facts pertaining to the case are necessary, it's reasonable to believe that when considering all of the relevant facts here, that Mr. Garcia Lopez may be smuggling drugs.
Counselor, I'm having an issue connecting the laptop with the smuggling of drugs and the nexus between the two and the timing. Are you suggesting that by virtue of a border search that we should be substituting the Border Patrol for the criminal investigations done elsewhere? Is this the proper place and forum for that kind of electronic search?
Your Honor, here, Officer Smith reasonably believed that Mr. Garcia Lopez may be smuggling drugs. And while it may not be physical contraband that could be found on an electronic device, digital contraband also exists, as in other cases where digital contraband such as child pornography was located on somebody's computer. This gives rise to the fact that yes, we should be searching for electronic devices, because while maybe he would not be able to find physical contraband, digital contraband may exist here.
Well, would it be feasible to conduct a search of every electronic device that was being brought into the country in order to determine if it contained some sort of digital contraband?
No, Your Honor.
Or would that be a waste of time and effort?
No, Your Honor, it would not be a waste of time and effort, given that Border Patrol officers are tasked with ensuring the safety and prevention of contraband entering this country and protecting the nation's border, which is a very real interest, which far outweighs that of a traveler's privacy interests, given that a traveler should anticipate a lowered sense of privacy at the border than they would experience in the interior of this country.
So are you arguing that examining every electronic device that comes across the border is reasonable?
No, Your Honor. However, if this court were to deem that reasonable suspicion was necessary, this court should still find that this search was lawful, given that reasonable suspicion did exist here. Your Honors, in the interest of border security and protecting this nation, petitioners respectfully request that this court reverse the lower court's decision for the foregoing reasons. Thank you.
Thank you, counsel.
Thank you, Counselor.
Respondent?
Good evening, Your Honors, and may it please the court. My name is Karen Petoske, and I represent the respondent, Mr. James Garcia Lopez. This search, the search of an individual's electronic device without a warrant, is an immeasurable intrusion of privacy. In this case, the petitioner's lack of even a reasonable suspicion when they rummaged through Mr. Garcia Lopez's laptop computer at will for 27 hours is just unreasonable, and it goes against what the Fourth Amendment stands for, despite the border search exception. As such, Mr. Garcia Lopez respectfully requests that this court affirm the decision of the 18th Circuit for the following three reasons. First, the search of an electronic device is so intrusive to an individual's privacy that it should be held to a higher standard than that required for a general personal effect at the border. Second, Customs and Border Protection agents' search of Mr. Garcia Lopez's laptop computer was really nothing more than a general search for evidence based upon a hunch. And third, at a minimum, reasonable suspicion was required for the warrantless, highly intrusive search of Mr. Garcia's electronic device. In 2014,
Excuse me, Ms. Petoske, can I bring you back to 1977, where in United States versus Ramsey, and if I'm prone to this rationale, I'll read the language. The court reasoned that it is the long-standing right of the sovereign to protect itself by stopping and examining persons and property crossing into this country. What say you?
Yes, Your Honor. In 1977, the controlling law from United States versus Ramsey does state that. However, at the time that case occurred, the court could not have possibly imagined the advances that technology would have had over the next 40 some odd years. We find ourselves now in a time where technology has changed the landscape of what should be permissible to be searched at the border without any kind of suspicion. While respondent does concede that the expectation of privacy is less at the border, the case Riley versus California also states that it doesn't mean that reasonableness just goes out the window in that case. There is still an expectation for reasonable privacy despite the border search exception.
Thank you.
Counselor, couldn't one argue to the contrary, that because of the advent of technology, that's even more reason to examine technological devices, and therefore the reasoning in 1977 is no longer applicable?
Yes, Your Honor. In this day and age, while there can be some sort of contraband carried in an electronic device, the idea of subjecting any traveler who crosses the border to a 27-hour-long detainment in order to search their device based on a hunch is flat out unreasonable. However, if there would be at a minimum, a reasonable suspicion standard, then we can prevent that subjecting of just random travelers to random searches for hours and hours, an unlimited amount of detainment. In this case, had Mr. Agent Smith considered all of the facts and circumstances surrounding Mr. Garcia Lopez's travel, he would have been able to quickly dispel any suspicion that he might have had. We believe that the only reason that Agent Smith even detained Mr. Garcia Lopez is because of his appearance, because he fit a profile, and he happened to detain someone the week prior and got lucky and found some contraband in that gentleman's cellular phone.
So taking the agent's history and experience, the possibility of notorious trafficking, what say you in connection with that profile?
While it's understood that agents are able to rely on their experience and their common sense conclusions, in this case, we don't believe that there was a rational inference for Agent Smith to conclude that Mr. Garcia Lopez was in fact a drug smuggler. Beyond just his appearance, he ignored every other factor surrounding his travel, and that should be part and parcel of Agent Smith's determination of whether to detain and search his electronic device or not.
So you're not questioning his authority to make a determination, but you're questioning what he actually determined. Are you second guessing his determination that this did pose a risk?
Your Honor, it is not only his own common sense conclusions that are at play here. He also needs to consider the facts and the circumstances surrounding the travel. For example, in United States versus Montoya de Hernandez, there was a suspected alimentary canal smuggler who had come across the border. When agents questioned her, she provided responses that were a little bit suspicious. She did not have a sufficient amount of clothing for a vacation or a trip to the United States. She didn't even have a change of shoes. She had no hotel reservation, no family in the States or anywhere to head to, and she was carrying $5,000 in cash. With every subsequent question, it raised the level of suspicion for those agents. And that, at a minimum, would give them the authority to detain her and to detain her long enough to dispel their suspicions or to verify their suspicions, as it was in that case. However, in this case, Mr. Garcia Lopez had a logical and rational explanation for his travel. He resides in the United States. He has family that he has visited in Mexico twice a year during his vacation times for the last several years. He's a student here in the United States. There really were so many logical reasons for him to be a lone traveler coming from Mexico. However, Agent Smith disregarded all of those reasons. The only questions that he asked were where he was coming from and what he was carrying with him. Had he taken the time to consider all of the circumstances that were surrounding the travel, he would have quickly been able to dispel any fears or hunches that he had that Mr. Garcia was, in fact, an a drug smuggler, which is distinguishable from the Montoya de Hernandez case several years prior.
You know, speaking, counsel, of Hernandez, it's been stated that no court has defined the specific level of reasonable suspicion necessary to justify an intrusive search, but have deferred to the officers. And so why are you now, moving away from that deference to the officer?
Your Honor, when it comes to the search of electronic devices, the level of intrusion is so vast, it is immeasurable, that we need to instate a higher standard for search. While it's understood that agents should have the authority to search any kinds of effects that come across the border, luggage, wallets, purses, things like that. When it comes to something like a laptop computer, the justification should change. The actual point, the main point of the Riley decision in 2014 is the Riley court's express refusal to treat a cellular phone, in that case, or electronic devices in general, as just another form of container. In fact, a traveler can come across the border with an address book, with a photo album, with even a diary. And those things are subject to search. However, in a laptop computer, it encompasses all of those things and then some. It is literally immeasurable, the amount of digital data that can be stored. And as they said in the Riley case, that it contains all of the privacies of life.
Ms. Petoske, to Ms. Goodman's point, there was a password that was given. What do you say to that?
Your Honor, while Mr. Garcia-Lopez did reluctantly provide his laptop computer upon being asked to present it, and while he did provide his password, I don't know that we should go as far as calling it consent. We've been conditioned in a way to respond to law enforcement. Here is a young man, he's a college kid, he's coming home from vacation, he makes it through the customs area and then subsequently gets detained by Agent Smith. He was understandably nervous and he wasn't given a choice to provide his password or to present his laptop computer for search. In fact, I would venture that most people would provide their electronic device and provide their passwords if they were asked by law enforcement. Law enforcement inherently has an authority, especially at the border. Especially.
Thank you. Thank you.
In fact, there was a case, it's a federal district court case out of Massachusetts, Al-Assad v. Nielsen, in which there were 10 detainees that were all combined who were asked to provide their electronic devices at the border. And the 3 who refused to provide their electronic devices had their devices confiscated. So it would not have done Mr. Garcia-Lopez any good to refuse providing his laptop computer or providing his password. What we really are essentially dealing with here in this case is that we have a rule of law that was established in a pre-digital era, and it has now become insufficient in this digital era. Technology has advanced so rapidly, and it is the aggregate of information that can be found on electronic devices that really needs to be considered when we're contemplating a standard for searching that device. In this case, we believe that more than a hunch should have been regarded in determining whether to detain Mr. Garcia-Lopez. Reasonable suspicion is defined as something that is based on very specific and articulable facts taken together with rational inferences of those facts. In this case, there were no rational inferences made between the reasoning for Mr. Garcia-Lopez's travel and Agent Smith's deciding to detain him.
Counsel, before you move too far, because I'm listening, what would that standard be that you suggest?
Well, Your Honor, this really goes back to what I was saying earlier, that there needs to be a sort of totality perspective here. If somebody comes across, as in the Montoya Hernandez case, and they're asked questions and their responses are kind of suspicious, they seem illogical, they seem irrational, then that would rise to a reasonable suspicion standard to at least detain and search until they can dispel or verify their suspicions. However, in this case, Agent Smith disregarded any kind of outside factors of why he would be traveling, factors of why he wouldn't have any luggage with him, where he resides.
But again, Counselor, aren't you suggesting now that you're asking us to second guess the independent judgment of Border Patrol? Have we ever ruled against a Border Patrol in favor of the right of privacy?
Your Honor, we've never ruled against a Border Patrol in favor of the right of privacy because we've never actually been confronted with something like this before. In fact, this case presents this court with an opportunity to protect the rights of travelers that are crossing the border. While we understand that there is a lessened expectation of privacy, it should not extend carte blanche to all electronic devices purely because of the factor of intrusiveness. In fact, the Riley court did hold that the intrusiveness in an electronic device is comparable to the most exhaustive search of a home, of a dwelling. If that were the case, then there should be a probable cause standard applied to electronic devices. There are things found in electronic devices that are not even found in homes in any form, but they're all compiled in one neat little handheld package here. And that is essentially what is unreasonable, and it's unjust for travelers who are coming into the United States. While we understand that electronic devices can carry contraband, as in that man that Agent Smith had detained 1 week prior to Mr. Garcia Lopez. However, it's not really the responsibility of the Border Patrol to have a general authority for just random law enforcement. We have other forms of law enforcement in the states for that reason. Even though Borders and Customs and Border Patrol agents have the authority to search for contraband and to prevent contraband from entering the United States, it's not really their responsibility to just search for crime. And that is, in essence, what happened here. And further, that is it's because of that, it's attenuated from the purpose of the Fourth Amendment, of the border search exception. Therefore, in the interest of protecting the right of an individual to be free from pervasive government intrusion, respondents respectfully request that this court affirm the decision of the 18th Circuit. Thank you, Your Honors.
Thank you, Counsel. Ms. Goodman, would you like to rebut?
Thank you, Your Honor. Petitioner has 1 point on rebuttal. Your Honor, here the respondent's reliance on the case Riley versus California is frankly inappropriate in this situation, given that the Riley case specifically references a search incident to arrest, and that is not analogous to what happened here. Your Honors, the border has been acknowledged to be a unique place which requires a unique set of controls as compared to other places in the interior. Given that it's unique and is a exigent circumstance in and of itself, the respondent really cannot rely on Riley, given that it is not analogous whatsoever and the border's unique exceptions. Thank you.
Thank you, counsels. Okay, we are going to adjourn. Go into chambers, I think.
Yes, Justice Stein, you will be put into a breakout room momentarily. Competitors, thank you so much. And Peter, you're on, and he should be moving you guys into a breakout room shortly. So just give us a few minutes. And
thank you, counsels, for an excellent presentation.
Okay, I think our judges made it into their breakout room to confer. They will be there for the next 10 minutes. Competitors, congratulations. You can breathe. You made it through the Bainbridge competition. We are so proud of you, and you guys did an excellent job. So Congratulations. Thank you so much for being here with us and for bringing your best to the 38th competition. So thank you all for tuning in to watch our competition. I would again like to congratulate our two finalists, Margaret and Karen, for putting all of their time and effort into this competition. I would also like to congratulate our semifinalists, Samantha Karpman and Lindsey Zager. Finally, I would also like to congratulate all of our new members, Conor Byrnes, Rebecca Carr, Casey Chung, Jennifer Coveas, Ingrid Fernandez, Margaret Goodman, Samantha Karpman, Amanda Pendel, Karen Petoske, Claudia Pius, Bryan Ramdat, John Reagan, Alexander Rogalski, Michael Sugamele, Raj Telwala, and Lindsey Zager. Congratulations to all of you for making it onto the Moot Court, and we are very excited to work with you this year. I do have a few awards that I would like to present. We have two right now. We have our best oralist is Jennifer Coveas. Congratulations, Jennifer. And best brief is Karen Petoske. Congratulations. You both will be receiving plaques very soon. We should have had them to present to you if we were in person, but of course, COVID. So we will get them to you, no worries. And congratulations to you both. The next award that I would like to present is the Judge George C. Pratt Moot Court Board Alumni Association Award in Appellate Advocacy. This award was established in recognition of the high standards of appellate practice set by the Honorable George C. Pratt, Circuit Judge of the United States Court of Appeals for the Second Circuit. The recipients of this award have enhanced our legal education through their contributions to the Moot Court program and by their close interaction with our members. The award recipients have demonstrated legal scholarship, professional excellence, and an understanding of the importance of moot court in our law school experience. We are proud to announce that this year's recipient is Dean Myra Berman, Associate Dean for Academic Affairs and Associate Professor of Law. We would like to thank Dean Berman for her incredible dedication to the moot court. Her unlimited support and guidance are what allows our honor society to grow and prosper. Dean Berman plays an integral role in the preparation and organization of our competitions and also serves as a mentor for each moot court member. Dean Berman encompasses all the qualities that the Pratt Award seeks to celebrate: professional excellence, legal scholarship, and dedication. Congratulations, Dean Berman. Now, I would like to thank our entire staff for their incredible dedication for preparing and mooting the finalists. I would also like to thank our dedicated and supportive e-board and senior staff for helping organize the entire competition from beginning to end. Special thanks to Lena Milazzo, our competition editor, and our research editors, John Bonanno and Christina Negri, for working so diligently throughout the entire summer to prepare the problem and assist with organizing the competition. Also, special thanks to our advisors, Professor Pocock, Elise Delafave, and Judge Hudson, as well as Dean Berman. Thank you guys so much for all the help along the way. And right now, we're going to turn our attention back over to our judges. They have another 5 minutes. This took a little bit shorter time than I thought. They have 5 minutes to confer. I think, Dean Langen, would you like to say something? I see you unmuting.
Sure, why don't I? I'll help you out, Allie. I knew you were running out of things to say. First of all, congratulations to all the award winners. Wonderful news. Congratulations to all the new members. I understand that the board was so impressed with all the competitors that this year offers of membership were actually extended to everyone that competed. So congratulations. Boy, Margaret and Karen, I was like nervous for you just listening to the questions that were being asked. I was like, I am so glad I am no longer doing appellate work, because those are the way those questions come. You both handled it remarkably well. Your poise, your knowledge of the record, your knowledge of the case law, your ability to spit out case names was really fantastic. You deserve a lot of credit for, number one, doing it in front of all of these people in a virtual environment, and number two, just based on the performance that you both gave. If I had to pick a winner, I don't think I could. I think you both were extremely talented, extremely well prepared, and extremely professional in your presentation. You will become fierce appellate litigators if that's what you want to do. So congratulations and good luck. Congratulations to Dean Berman. I know she has her video off. I don't know if she has stepped away, but if she hasn't, she may want to say a few words because she has done such a remarkable job with the Moot Court Board, and I know spends countless hours not only working with the competitors, but also counseling them on many of their issues that may not be related just to Moot Court. So Myra, do you want to say anything?
I'm so choked up right now. I really am. Karen is smiling and so is Margaret. We really tortured them. Allie and I tormented them for the last 2 weeks, and boy, did it pay off. I am just so filled with pride at the accomplishments of these two women, these two incredible law students. I can't really even speak. I am moved beyond expression at the Pratt Award. Most of you don't know, but George Pratt was my very first law school professor. The day I came in, we had him for civil procedure, which he was a full-time member of the faculty at the time. And I have a very strong attachment to him personally as well. But what happened here today for the very first virtual Moot Court competition is just extraordinary. It's miraculous. It couldn't have happened without certain people. Allie, I have to give you a specific individual shout out. Everything that occurred today occurred under Allie's leadership with her phenomenal staff and her phenomenal editorial board. But again, all my kudos go to these two competitors. Just an extraordinary job. It brought me back to my own Bainbridge performance in 2003. And that brings back the best of all possible memories for me. So congratulations to both of you. As I said, beginning when not everybody heard, but what I said at the very beginning was you are both incredible winners, no matter who won this particular round. Thank you, everybody.
Thank you, Dean Langan and Dean Berman. We appreciate all of your kind words.
Thank you all. Thank you, competitors. It is really easy to pick a winner because you're both winners. And it is really hard to pick a loser because neither of you is a loser. We all came to the same conclusion. We are all equally impressed. We all really thank you for your participation and for your enthusiasm, knowledge, preparation. I think it's fantastic. I could never have done that when I was in law school, and I don't even think I could do it now. But you guys are really wonderful, and I know why you made it to the finals, and we want to congratulate you both. I think we're going to each individually give, Allie, would you like us each individually to give an analysis?
If you would like, Howie, whatever you want, you could deliver the verdict, to who won, who didn't win officially, and then you can each give individual feedback if that's what you'd prefer. Okay,
we decided that Ms. Petoske was the winner. But like I said, Ms. Goodman, we congratulate you for a wonderful presentation. We both thought you both presented your arguments. They were both focused. They were both from the record. You both did exactly what we thought you should do. You both had a lot of enthusiasm and poise. I think, and again, the margin was, both of us believe the margin, all three of us believe the margin was very small, but we thought that Ms. Petoske had a better pivot from questions back into her argument. We asked a lot of questions. We thought you handled the questions very well. They were not easy questions, and we thought you handled it well. Ms. Goodman did a wonderful job on the questions as well. We all felt that the rebuttal was a little on the weaker side, that your initial presentation was excellent. The rebuttal, you might have been better off not doing it. We didn't think you came back in nearly as focused on the issue at that point in time. But otherwise, I think this is. I'm really proud to be part of Toro Law School, to see the quality of how you both performed under these circumstances. Judge Robinson, or would you like to?
Well, yes, you give me a mic and I'll always want to talk. But I want to commend both of you for an outstanding presentation. Each of you did magnificently. What I'm seeing here are professionals. What you presented today was done in a very professional manner. It was organized. I have argued in the appellate division. I've argued in the Second Circuit. I've argued in the Court of Appeals. And you could stand up and argue before any one of those courts. You could argue in the Supreme Court because of the way that you prepared and were so passionate about your arguments. And so I commend both of you so much for the way you've done. You've done Toro proud. You've done the legal profession proud, that we know that we've got up and coming lawyers that are going to be able to go to battle on behalf of their clients. Thank you all so much.
I would simply adopt the other judges' comments and simply leave it with this. What I mean by pivot is weaving the law, the facts, and then going right back to your argument. The law, the facts, and right back to your argument, because that's what we're called to do as attorneys. And both of you did an outstanding job. And as the other judges have said, I was just very pleased to be a part of it. And congratulations to you both.
Thank you so much, everyone. We really appreciate our judges for being here. Thank you. We appreciate our large audience for coming and supporting Margaret and Karen. Congratulations again to you both. And I hope everyone has a wonderful, wonderful evening. Take care, everyone.